What I have for you today is two interesting cases about community law, transfer pricing, BEPS, and the freedom of establishment, which is the community law that we're talking about, both for the EU and for EFTA, and I'll explain in a moment what those are. Now, I really want to focus on the transfer pricing aspects of these cases, so I'm not going to go into too much detail about EU law and EFTA law itself. But what you see here is the inside of the EU Court of Justice, or the Court of Justice of the EU, I should say, which is the right term to be using. And here we can see what are EFTA countries and what are EU countries. The EU countries are the countries in blue. They all are also members of the European Economic Area, but those countries which are not member of the EU form part of EFTA, so that's Norway, Iceland, and Liechtenstein. And then Switzerland has a special status within EFTA because, for instance, it is not subject to the EFTA court, if I remember correctly. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Let's get to our cases. The first case is from January 2021, and that is Lexel AB, and that was from the Court of Justice of the EU, and it deals with freedom of establishment and limitation on interest deductions. And then we have a much more recent case from the 1st of June 2022 from the EFTA court, which deals with the EFTA countries' freedom of establishment and the treaty setting up the European Economic Area and the EFTA area and stuff like that. And that too deals with the freedom of establishment, and it concerns the PRA group Europe AS versus Norway. So if we start with what the freedom of establishment is exactly, if we look at the Treaty on the Functioning of the EU, then you can see here Article 49 talks about the freedom of establishment. So remember, the EU is trying to form an internal market, right? So that things can move as easily and people can look for jobs as easily within the EU as they can, for instance, within all the different states of the US if they are US citizens, right? So what 49 says is, within the framework of the provisions set out below, restrictions on the freedom of establishment of nationals of a member state in the territory of another member state shall be prohibited. So you can go everywhere, anywhere, and as easily as you can in your own home country. Such prohibitions shall apply to restrictions on setting up of agencies, branches, or subsidiaries by nationals of any member state established in the territory of any member state. And now, as far as companies are concerned, if a company is incorporated under the law of a member state, then the company is deemed to be a national of that member state for purposes of the Treaty on the Functioning on the EU. And then it goes on to say freedom of establishment shall include the right to take up and pursue activities as self-employed persons and to set up and manage undertakings in particular companies or firms within the meaning of the second paragraph of Article 54 under the conditions laid down for its own nationals by the law of the country where such establishment is effective. So you gotta treat the other EU citizens the same as your own citizens if you are an EU country, subject to the provisions of the chapter relating to capital. There are some grandfathering clauses in the chapter on capital, but obviously the treaty is also quite old, so those are expiring all the time. Now, if we look at the convention establishing the European Free Trade Association, or EFTA, and this is consolidated version from 13, then it's very much the same, right? We're talking about establishment, we're talking about investment, and then establishment. And EFTA and EU are very similar in many respects. You can see the duplication of a lot of the EU articles in the EFTA articles. The integration is just not quite as tight as it is in the EU, and there's not talks about joint military force and stuff like that as we now have due to the Ukrainian threat. So Russian threat in Ukraine, I should say. Within the framework of and subject to the provisions of this convention, there shall be no restriction on the right of establishment of companies or firms formed in accordance with the law of a member state and having their registered office, central administration, or principal place of business in a territory of member states. This shall apply also to the setting up of agencies, branches, or subsidiaries by companies or firms of any member state established in a territory of another member state. So it's very much the same, with some different words, but the same content as the Treaty on the Functioning of the EU. The right of establishment shall include the right to set up, acquire, manage undertakings, in particular companies or firms within the meaning of paragraph 2, under the condition laid down for undertakings by the law of the member state where such establishment is effected. So let's get into the facts. We'll look at Lexel first. Lexel concerns the French group Schneider Electric SE, and Schneider Electric SE was established in France with corporate tax rate 34.43%. This is important because we'll get back to that. And it had a number of subsidiaries in France, including Schneider Electric Industries SAS and a finance company, I believe, BF SNC. And then it also had a subsidiary in Belgium called CJEU, Schneider Electric, whatever it is, and it was held for 85% by Schneider Electric Industries in France and for 15% by a Spanish subsidiary, Schneider Electric España, I believe it was. And there was Lexel, together with some operating companies in Sweden, and as you can see in Sweden the corporate tax rate is 22%. Now what happened was that SEE in Spain wanted to buy some external companies outside of the Schneider Group, and he decided he needed to change it to equity ratio, apparently. So it then sold its participation to Lexel, and Lexel borrowed from BFS&C, and then Lexel used the group contributions from the operating companies to pay the interest on the loan to BFS&C. And now there are two different points here. The first one, as far as Spain and SEE is concerned, what the Swedish tax authorities said is they said, no, it's not true that SEE only made a foreign acquisition. The problem is also that SEE was beginning to make losses and it couldn't effectively deduct its interest anymore. That was part of what the Swedish government argued. And then with regard to Lexel and the OPCOs, Sweden has a system, and I believe it was used here, which is part of the case, whereby companies within Sweden can give group contributions, tax-deductible group contributions, to other companies and group members within Sweden, right? So if you have an operating subsidiary which is profit-making and you are a parent company in Sweden that is loss-making, then the operating company, you can't consolidate your results, but you can achieve the same effect whereby the Swedish operating company gives you a tax-deductible contribution, so it doesn't pay tax on its profits anymore, and then you take those profits as the Swedish parents and you offset that against your interest deductions, for instance, so you don't pay tax on it either, right? So it effectively becomes a consolidation of the tax results. So these were the facts so far. Let's just have a look at a few of the more facts. If we look at the court decision itself, there are a number of things that are mentioned. Lexel made loan interest payments to BF of 58 million Swedish kroners, and there's, I think, probably about 8 or 9 kroners in a dollar in 13, and 62 million in 2014. BF used the interest amounts to offset deficits that had been in the activities of companies established in France, which form part of the tax entity. So in France, there was also consolidation going on, and even though BF received taxable interest income, that interest was effectively not taxed because it was used to offset other French companies' losses, right? Lexel stated that it bought the SESI shares from SEE because SEE required capital to finance the acquisition of a company outside the Schneider Electric Group. Against that background, SEE had decided to sell the shares it owned in SESI. Now there are a number of questions to ask here. I mean, one of the most obvious ones would be, why didn't he simply sell the shares SAS in France. So it became a 100% shareholder, or I don't think you can hold 100% of the shares of a Belgian company, but then a 99% shareholder, and then let BF hold 1% or one share in CJEU Belgium, right? I mean, there could have been other ways of solving this, so one has to bear that in mind too. And then, according to the tax agency, the transactions were carried out, and this is the Swedish tax agency, were carried out so that a deduction of interest costs could be made in Sweden rather than in Spain, with a view of gaining a substantial tax benefit. And the substantial tax benefit then being there were no more profits in Spain to deduct against, and by moving it to Sweden you could offset it against the group, the OpCo's profits, while you still didn't pay tax on the loan in France because you offset the interest income against other companies' losses. So you get a deferral, right? Because in time, obviously, those losses will now be eaten up sooner. And then just a summary of the Swedish rules that are relevant here. First of all, intragroup interest is deductible if the creditor is taxed for at least 10%, right? That's the first rule if the creditor is abroad, right? However, it is also deductible if it's taxed for less than 10% and is incurred mainly for business reasons, the loan, and the creditor is in an EEA state, so either an EFTA state or an EU state, right? Because those two together make the European Economic Area. But it is not entitled to deductible if the main reason for creating the deduction is a substantial group tax benefit, and main reason apparently in the parliamentary is to find us more than 75% of the reason for the transaction, unless the creditor is subject to tax in Sweden on the interest. So if the creditor is a Swedish company, you can deduct the interest even if it is done for a substantial group tax benefit, but you can't deduct the interest if it is not a Swedish company, right? And something bites here, because if a Swedish debtor pays interest to a Swedish creditor, the one deducts it, the other one is taxed for it. Where is the substantial group tax benefit, right? I mean, it almost seems like a non-reason, but we leave that aside. I think the court does mention it, but I'm not 100% sure about it. And then the further issues for the court is whether the cross-border and international situations are comparable. Now, obviously, in order to find out whether there's discrimination, there's the fact that if the creditor is Swedish, you can deduct it. If the creditor is not Swedish, but within the EEA, you cannot deduct it. You need to be sure that the situations are comparable, right? And the court then says whether cross-border and national situations are comparable is a matter which must be examined having regard to the purpose and content of the national provisions. And then it answers the question. It said it must be held, as the European Commission has submitted, that a situation in which a company in one member state makes interest payments to a company established in another member state is no different from a situation in which the recipient of interest payments is in the same member state, right? So yes, they are comparable. And you will see in the numbering here, the court actually threw the argumentation a little bit around, but then it also goes on to say, in the light of those factors, it must be held that in the present case, there is a difference of treatment which has an adverse impact on the exercise by companies of the freedom of establishment, right? Because these situations are comparable, but if you are abroad, then you can't get the interest deduction. Such a difference may be comparable if it relates to situations which are not objectively comparable or is justified by an overriding reason in public interest and is proportionate to that objective. But we already see the court has said that, or European Commission has said, and the court has followed, that this situation is comparable. So now we need to find out whether there's any other justification